Hello, good afternoon everyone. Today we have continues our last lecture, the Indian Evidence Act 1872. Some features of the Indian Evidence Act are as under adjective law. This act is adjective law, neither procedural law nor substantive law. It provides both combination of the both of them. That is adjective law. Next, this law is Indian Evidence Act is lex puri. Lex puri means place of the trial. Okay, place of the law where the trial is began. Okay, the Indian Evidence Act means when any person committed any offense any other country, then their Evidence Act is applicable, not here a Evidence Act applicable. Okay, the Indian Evidence Act is applicable only in India, only in India, within the territory of the India. Lex Puri is second features of the Indian Evidence Act. Next, fallacies ino omnibus has no application in India. Means when one person thinks said any one thing or one statement, then those persons considered as a wholly lie or false. This is not applicable in India. Uh, has no application in India. This maxim forces in uno, forces in omnibus. Next, basic principle of law, hearsay is not allowed with some exception. Hearsay is not allowed, but allowed permissible in some exceptional cases. For example, dying declaration, rule of res justia, it is allowed. Otherwise, it is not allowed. Next, only for facts in issue, relevant facts and no others. Indian Evidence Act clearly, expressly mentioned in under section 5, when any person gives evidence or willing to try give evidence, then only for facts in issue, relevant facts and no any other evidence is allowed to put up before the court of law. Okay, that means facts in issue, relevant fact is considered by the court of law and no other. Next, best evidence must be given. Best evidence must be given means when evidence is available to the party, then which in them best evidence must be put up before the court of law. Okay, adversarial or adversary system and not inquisitorial legal system. Adversarial or adversary system means, for example, when we see the cricket match, then umpire is neutral person, not belong to the any one team. For example, Australia versus India, then umpire belong to neutral means no, he gives his judgment in not in Australia, in favor of Australia or in favor of India on bias. Okay, an adversarial system, not a part of that team, due to bias system. Next, presumption of in innocence with exceptions. Presumption of innocence means in Indian legal system presume that innocence, every person considered as a innocence. The burden of proof lies on that person who claim against that person or who allegation on that person, burden of proof on that person. But in some exceptional cases, as like a consent of rape, yeah, or any other undue influences positions of that person, that person not considered innocence. Okay. Next, standard of proof, civil and criminal proceedings are different. Preponderance of probability and guilt shall be proved beyond reasonable doubt. Okay. Uh, Preponderance of probability belong to the civil cases, civil litigation matter, and guilt shall be proved beyond reasonable doubt in criminal matters, criminal system, criminal justice administration system. Okay, preponderance of probability means here probability, court give judgment, decree, order on the basis of the probability of the party, probability of the fact. But in case of criminal cases, here guilt shall be proved beyond reasonable doubt. Means when any person claim claim anything, any object, then must be proved that beyond reasonable doubt. If we, For example, if I said that so and so persons committed robbery, theft, then burden of proof on me to prove beyond reasonable doubt, not any, if any doubt is arise, then must be favor, doubt must be favor to the accused person. Okay, thank you very much. If you have any query or doubt, then post me on our Google Classroom link. Okay, thank you very much and good day. Take care.